Good afternoon, everyone. My name is Jared Friedman. Welcome to today's webinar on the new modernized marketing rule and advertising rule. Today we have with us Anna Povinelli, a managing director at Kroll in their financial services and compliance and regulation group. And we have Scott Moss, who is a partner at Lowenstein Sandler in their investment management group. Anna, just to give you a little bit of background on our panelists before we kick it off, Anna has over 15 years of compliance experience. She is a former CCO herself. She has supported advisors through countless SEC examinations. She's a trusted partner for wealth advisors, hedge funds, domestic and offshore private equity funds. And she, is a certified public accountant, so she brings that lens to all of her examinations and to assist all of her clients as well. Scott is, like I mentioned, a partner at Lowenstein. He is the co-chair of their compliance and regulatory group. He is Chambers ranked. He has been a professor at Rutgers, an adjunct professor at Rutgers, teaching a class on regulatory compliance for over 10 years. Like I said, over 20 years of compliance experience. And he is a trusted partner in all aspects of the compliance and regulatory oversight, both from start to finish for all of his clients. So welcome, Scott. Welcome, Anna. Thank you for your time, and thank you for being here.
Thanks for having us.
Thank you, Jared. Appreciate that. I'm sure you're all here waiting to hear about the exciting information on the new marketing rule that we are all aware was issued in December of last year. Under the Investment Advisors Act of 1940 has now been, the old marketing rule has been expanded, and is specifically the definition of an advertisement has been expanded to include and acknowledge the advances in technology and the use of technology in advertising by advisors. The rule also merged in the cash solicitation rule and now allows for paid endorsements and testimonials. Many advisors are now excited about the opportunity to utilize testimonials and endorsements. However, there are required disclosures surrounding both direct and indirect compensation that we will discuss today, including the analysis of potential conflicts of interest. The rule also places requirements on the presentation of various types of performance, such as gross versus net, hypothetical, back-tested, extracted, portable, and stipulates certain time periods which performance must now be disclosed. The final rule also addressed third-party ratings and will require additional disclosures in order to allow investors to better appreciate the third-party rankings and dissuade advisors from falsely using third-party rankings. Of course, there'll be additional books and records requirements. And finally, commencing in 2023, Item 5 of Form ADV will be amended to include specific information regarding the advisor's use of the new rule and advertising methods that are being utilized. Advisors must adopt the entire rule at the same time. So you have from now until November 4th of 2022 to adopt the rule. These changes highlight the importance of compliance being woven into all aspects of the advisor's business and to allow for the identification, mitigation, and disclosure of risks and certain conflicts of interest. Time will tell if the new marketing rule will significantly impact the approach advisors take towards marketing. So we are eager to see and discuss the implications of the new marketing rule with our clients. Scott, if you want to discuss.
Sure, I'll just add my overview thoughts on top of that. Yeah. And that was a great tee up of the new marketing rule. I'm unsure whether to call the existing marketing rule the old marketing rule or the current marketing rule, because as you said, there's a new marketing rule, but you could comply with either one right now. But it's an all or nothing approach. You have to pick one. After November 2022, the new marketing rule is the way to go. Everybody has to comply with that. But right now, folks have a choice. Investment advisors can choose to go with the current one, which is why I'm a little bit hesitant to call it the old rule, because you could still be complying with it, or the old cash solicitation rule, or you could still choose to comply with the new rule, but it has to be one or the other, not a mixture of both. You know, when I was kind of thinking about this webcast, I forgot how old the current rules or old rules are. You know, the initial advertising rule was made in the 60s, and the initial cash solicitation rule was made in the 70s. And a lot changed in how people market, how investment advisors market. You know, so when you think about those old rules, that was pre-internet, that was pre-social media, pre-websites. So it was really, the new rule, you know, in some ways are big changes, and in other ways it's just an acknowledgement of how advisors market now. And the old rules had prohibitions that didn't really work anymore. And the SEC kind of cut away at them anyway through no action letters, through guidance, through interpretations. And the new marketing rule kind of brings all that current. And it's really interesting to see what the SEC accepted, you know, in their current guidance or their decades old, you know, Clover Capital no action letters, and what they didn't incorporate in the new rule. And the new rule is so subjective. You know, when you're kind of reading the tea leaves, it's really helpful to think about specifically what they kept and specifically what they got rid of and what that might mean. So, you know, that's my overview of the new rule. Is it's in some ways, you know, really new, and in some ways it's just acknowledging, you know, what's already been, and that the old rules were antiquated.
Yeah, and Scott, I agree with your assessment, because oftentimes our clients ask us, well, how is this going to affect me? And it really depends on the type of advisor. You know, we deal with a lot of wealth advisor clients. I believe those clients are actually looking forward to embracing the opportunity to use testimonials and endorsements, which we will discuss. And if, you know, hedge funds, private equity firms, they're still assessing the implications that'll have. However, to your point, we've seen a lot of advisors using, you know, digital media for advertising and promoting information. So yeah, it was about time that they recognized the digital media's impact on marketing and the use of it, and trying to address it in this new rule.
Yeah, and I've kind of seen similar to that, you know, split on who wants to actually move to the new marketing rule. And I've seen that kind of split in type of advisor come out a lot. A lot of the private fund managers that are listening right now, they're probably not as much in a rush to come over to the new rule, because the new rule specifically applies to fund investors and to funds now, as opposed to, you know, those digital market robo-advisors or digital advisors or wealth managers, as you put it, what I call more traditional managed account advisors, that might be in a real rush to move over to the new marketing rule because they really want to use those testimonials and endorsements now. And, you know, in the pre-call, we were talking about 506C, you know, and some people were really excited over 506C. You can now use general solicitation. And for some private fund managers, it was just a blip on the screen. They didn't care. It didn't really affect how they marketed. It didn't affect their business. But on the other hand, some advisors kind of grew up a new industry around it. So I think the new marketing rule is going to be the same way. You know, some advisors are going to embrace it and be really innovative and novel and take the risk that comes along with that. And some managers, it'll be a blip. You know, we'll have to update their policies, but they're not really going to change how they currently market. It's not really going to affect their business all that much.
Mm-hmm. Right. So yeah, I mean, take the lead. How are we defining an advertising?
So let's dig in. So, you know, in your overview, you said there are two prongs to the advertising rule, and that's of course absolutely right. So prong one is what we traditionally think of as advertisements, and then prong two was the testimonials and endorsements, and we'll get into that later. That prong one in what is an advertisement, it really broadens up now what is considered an advertisement from what it used to be under the old technical rule. The old technical rule, you know, referred to things like TV and radio ads. And again, you know, some investment advisors advertise through TV and radio, but even those investment advisors is probably not the only way they advertise. So the new rule focuses it more broadly. So it's, you know, are you offering essentially advisory services to prospects, whether that's clients or whether that's private fund investors, or are you offering new advisory services to even folks that are current clients or current prospects? And it essentially covers all direct and indirect communications, and that indirect communications kind of freaks me out a little as to where the SEC is going with that. That offers those advisory services, and of course it has to be with respect to securities because that's what the Advisors Act is all about. But it includes communications to more than one person, and it includes communications that are even to one person, generally speaking, if the advertisement includes hypotheticals. And then it has certain specific carve-outs. So it carves out live, oral, extemporaneous communications. It carves out information in a regulatory filing that has to be there. So kind of key caveat, right? Has to be there. We're supposed to be there. It carves out hypothetical performance when it was solicited. And it carves out hypothetical performance to fund investors in a one-on-one meeting. So, that's a lot to think about in your framework of what is an advertisement now, both direct and indirect. So it doesn't just have to come from the advisor. And it's a lot to think about in those carve-outs, because when you think about those carve-outs, what really is extemporaneous and live and oral. So if you have a pre-recording, if you have a presentation that you click play on while you're speaking live, that can still be an advertisement. When is something really solicited? When does an investor truly say, I would like to see this performance advertisement presented in this way, calculated in this way, and it's, completely no kind of, leading the investor there, that is completely unsolicited request. When do you go beyond a legal requirement? We had this when Form ADV 2A came about, and we thought about, whether the 2A could be a general solicitation because you're talking about private funds. Now it's the same thought. Is your 2A an advertisement? Is your private placement memorandum an advertisement? Because do you go beyond what's, really, really required to be in that filing, beyond the terms of the fund, to talk about, predecessor performance or predecessor funds or future funds? And then, in a one-on-one communication, when is that really bespoke? So in my experience, the one-on-one communications, a lot of times there's a pre-approved template. And even though on the cover page of it, it says, this is for the presentation to Anna Capital Management, that same presentation was really used a whole bunch of times. And each one, it might say on the cover, this is for this institutional investor, or this is for this client, but the base of it is used over and over again. So the advertising definition is now really broad. It was intentionally broad, and the carve-outs are narrow and might be even more narrow, than they appear on their face.
Right. So I think the devil's in the details, definitely, from reading this rule. There's so many nuances. Just to make one point clear, so the what is an advertisement is really like more for new services. So ongoing investor letters and updates are now not considered advertisements under the new rule?
So, so the investor letters, alone in a vacuum, I think similar to the old rule or current rule, investor letters aren't necessarily advertisements. So if you're talking about the existing products to existing investors or existing clients and their portfolio, it's not an advertisement. Right. But if you offer new advisory services, as they are, right. And right. Again, that distinction is a little bit less practical to me, because in practice, those letters have legs. The right. Annual meeting, same thing. If you're informing existing clients and investors about their existing portfolio, that's not an advertisement. But the likelihood that a prospect attends that meeting, in my experience, is high. The likelihood that a prospect sees that investor letter is high. Maybe it's one-on-one, but you have to be really careful, as to what to treat as an advertisement. And from just a compliance standpoint, I'd err on the side of thinking things are advertisements, especially where their use could be.
Right. And oftentimes the SEC will come in and examine and will request all communications to investors. So, regardless, I think the, chief compliance officer should, review and be aware of what is being disseminated to all clients and investors or prospects.
Yeah, and I think that's the biggest thing, is what kind of review does the chief compliance officer, the compliance program, want to provide? And in mm-hmm. addition to thinking about, what is an advertisement, I'll add a second point of, so what? So what if we think something's an advertisement or we think it's not? If we think an investor letter is not an advertisement, what does that practically mean for your firm? Does that mean compliance doesn't review it? Probably not, right? Compliance probably still wants to review it because you still don't want to mislead. But maybe, to your point earlier on the net regross, maybe you could give gross only performance, or maybe we could be a bit more freewheeling on talking about specific portfolio investments, on past specific recommendations or current recommendations. And we'll get to all that in this webcast. But for things like a private placement memorandum, deem it an advertisement or not, to me, I shrug and say, so what? I'm not going to do anything differently in a private placement memorandum, because even if it's not an advertisement, it's still an offering document for a securities offering. So I'm still having, multiple layers of internal review. I'm still controlling its dissemination and how it's disseminated. I'm still documenting all my support for everything that's in it. And I still wouldn't have something that could possibly be misleading. So whether I view that as an advertisement or not, it doesn't really change. But there will be some forms, that might change your review, but you have to think about it. The compliance people that are listening right now have to think about, what does that mean for your policies? How does that really change your review and your standards?
Yep. So you mentioned prong 1, so I just wanted to go into prong 2, the very sexy testimonial and endorsement prong. So the SEC recognizes the overlap in the approach to solicitation and has now expanded the definitions to include testimonials and endorsements. And this particular prong is designed to capture solicitation activities that were previously subject to the cash solicitation rule. So a testimonial, there's specific definitions for what is a testimonial, what is an endorsement. A testimonial is a statement by a current client or private fund investor advised by the investment advisor. So basically it will be, about from the client or a private fund investor's experience with the investment advisor or its supervised persons, so-and-so has been responsive to me and has, conducted their business as expected and surpassed my expectations, whatever statement that particular testimonial would like to say. And it gives that person's distinct perspective on working with that particular advisor. An endorsement, on the other hand, is by a person other than a current client or private investor, and they still must have had some sort of interaction with the advisor and will still continue to indicate, some sort of support or recommendation for that investment advisor. And that person providing the endorsement or the testimonial can be in a position to solicit current or prospective clients to the investor. And in that regard, we're going to get into whether or not these testimonials are paid either directly or indirectly. And there are a lot of disclosures that are conditional to using testimonials and endorsements. And these disclosures must be clear and prominent and provided to the to the prospective client or investor at the time that the testimonial or endorsement is provided. Specifically, and I guess we'll get into these, but just on a high level, there need to be the prospective client or investor needs to be aware of whether the person is getting paid, if there are conflicts of interest, and if that person is a bad actor, we cannot use their testimonial or endorsement. And if they are being compensated over a de minimis amount of $1,000, there must be a written agreement with that person providing the testimonial and endorsements.
Yeah, and just to add one thought, you mentioned the direct and indirect compensation. It's also now cash and non-cash. So it's really broad. And, remember, for those private fund managers listening, this now applies to private fund investors. So, the cash solicitation rule, and one of the reasons that fund managers aren't in such a rush, in my experience, to move to the new marketing rule is this second prong. Not so much the first prong, but the second prong that brings in the cash solicitation rule in addition to testimonials and endorsements you might find in otherwise advertisements. But it applies those rules to fund investors, not just your prospect investors, your placement agents, that are soliciting, but even to existing investors. And we can get into that more, in detail later on, but that's one of the hesitations I really see is this second prong for fund managers and not being in a rush to move to the new rule.
Mm-hmm. Okay.
Just,
Sorry, Jared.
Well, you guys both mentioned the private fund managers. So as it relates to the testimonials and endorsements, if a client is endorsing the private fund manager, do they specifically need to call out that they're endorsing the private fund itself? Do they need to identify that they're endorsing the investment advisor? How do you guys think that will sort of be attacked, and what do you think the best approach is there?
So yeah, I think as part of the testimonial or endorsement, they do need to, endorse that an advisor or fund or experience with that private fund manager. Does the manager have to disclose who the person is? No, they do not have to actually name the person. However, having said that, I think the purpose of that would be to give assurance that the promoter actually is in a position to endorse the particular fund manager. However, to keep personal information private, the final rule did not necessitate the disclosure of that particular endorser or person providing the testimonial.
Yeah, and Anna, that's probably oh, sorry, go ahead, Jared.
Sorry, Scott, just to follow up on that, do we have to disclose if it's a current or prior client? I know you mentioned we don't have to disclose the name, but do we have to disclose if it's a current or prior client?
Yes, they do have to disclose that because the prospect may put more value if it's a current client versus, somebody who's dealt with that particular advisor, 5 years ago, 10 years ago. Things have changed. So I think the reason of these testimonials and endorsements is to provide, more information and comfort, I guess, reliance on the advisor based on these testimonials or endorsements.
And I think that's a really good segue into the general prohibitions, which, Anna, you could tee up, because I think one misnomer about the new marketing rule is suddenly we're going to see, like, at the top of people's websites or at the top of an advertisement, something that says, this specific person says that we are the greatest advisor to ever live, period, or in quotes, or some kind of single rosy quote like that in a press release or by portfolio companies or by borrowers or existing investors or existing clients or any third party you pay. That's still very likely not going to be the use of this rule, because while the prohibition against testimonials and endorsements was removed, it didn't remove all the stuff around it. And there's general prohibitions of still being not misleading and fair and balanced and not cherry picking. So where testimonials are probably going to come is in kind of bigger uses of social media, on conferences, on allowing employees to use more of their LinkedIn or more of their social media sites. But it's not going to be that single, quote of these people are amazing, you definitely should give them money. And I think that really tees up the general prohibitions. So,
right. Yeah, so advisors have to consider the facts and circumstances of each investment and the nature of the audience to which the advertisements is directed. That has to be a key factor in determining how the general prohibition should be allowed. Scott, I think you had mentioned some, but what the general prohibitions are: no untrue statement. So you can't use somebody's testimonial or endorsement if it's untrue. Also, as another example, maybe omitting an applicable benchmark for comparison. So, and I believe, most advisors were still working under a premise of this prohibition of no untrue statement, but, now it's actually incorporated in this rule. No unsubstantiated material statement of fact that can make a statement that it cannot be supported under exam. So whatever material statement of fact that you're putting forward, you must be able to provide support should the SEC come in and request for that supporting documentation. And we emphasize that all the time at Kroll, that for all performance related data, any underlying material statements that an advisor is making, you must have the data. Compliance should be reviewing that data as well. There shouldn't be any untrue implications or misleading implications or misleading references. That's an additional prohibition. So an example of this is if you have a series of true statements, each statement can be true, but together they can be misleading. So what do I mean by that? So for an example, if you have an advisor that has, say, 100 clients, and they say, oh, I have 100 clients that have stuck with me for over 10 years, but alone that statement sounds, wow, this advisor is, has a solid group of, quote unquote, sticky clients. However, the advisor may have omitted the fact that, he or she has had a high turnover of clients. So just again, making sure that there's no misleading implications as part of those statements. Fair and balanced treatment of material risks and limitations. I love my fair and balanced standard that I found within the rule, and how the SEC defines fair and balanced is an advertisement that references favorable or profitable past specific investment advice without providing sufficient information and context to evaluate the merits of that advice is not fair and balanced. So I can provide you that in an email if you want to follow up with a request, but fair and balanced is really critical, especially with, the pitch books and the decks and, a lot of oftentimes our clients, prepare cases. And that kind of leads into our next, cherry picking provision. You cannot just cherry pick certain winners that you have had in your experience as an investment advisor. Again, it has to be fair and balanced. You have to also present some losers and maybe just analyze, what you've recognized through that experience with an investment that didn't go as planned. Lastly, the material cannot be materially misleading. And the commission only needs to prove negligence on any one of these general prohibitions to cite an advisor. I don't know, Scott, if you had any additional
yeah, I mean, I tend to summarize that. Yeah, that's a great summary of the 7 principles, and I tend to summarize that with do not mislead, do not cherry pick, and be fair and balanced. And that kind of borrows from a 10B, 10B5 standard, and the fair and balanced borrows from FINRA 2210, which is FINRA's advertising rule. But, one thing that's a little bit wild about the new marketing rule is, it takes you 5 minutes and a page, to talk about the 7 principles, including that 7th principle of not being otherwise materially misleading, which is kind of hard pressed to find a presentation that would completely be okay under 1 through 6, but violate 7. I know the SEC gave an example of a really small font, but everything was otherwise true and not misleading, but the font was not legible. But it's completely subjective. So when you have rules that take a page to list out, and then the final rule release spent 400 plus pages talking about those, it's safe to say it's really subjective. And one of the things I find fascinating about the new rule is the intended audience matters, the facts and circumstances matter, but the SEC declined to put in like really specific requirements on retail versus institutional or non-retail investors. They just gave the principles. So you could have 2 identical advertisements, and depending upon the audience or depending upon the distribution channels, one is deemed misleading and violating the rules, and the other is deemed perfectly fine under the rules, and they're identical. So it puts a great deal of pressure on compliance for those really robust internal reviews. It puts a great deal of pressure on record keeping, which I know is nobody's favorite topic, but the need now to document the reviews, to document the basis of fact, or anything that's purported to be fact, is really, really heightened, and contemporaneously with the advertisement, not after the fact. And the need to control the distribution channels is really heightened, because there's things that you can easily write on a PowerPoint presentation and disclose on a PowerPoint presentation in a really fulsome manner, or in a PPM, that's really hard to do in social media or Twitter. And the clear and prominent versus, what can come later, matters in what's deemed misleading and what's deemed not. And, it's almost like an obscenity standard in that Supreme Court case that we all know and love, or any of the attorneys on the call know and love in law school, where the Supreme Court said, I know it when I see it. This is almost an, I know it when I see it standard, good luck. And, and risk tolerance is going to matter a lot here, because there's no market standard under the new marketing rule. There's marketing standards that can inform it under the current or old rule, but there's no market standards in the new marketing rule. So there's going to be advisors that play it safe, and there's going to be advisors that really push the limit, and that risk tolerance will matter. And just one more thing to add on the general principles. I'm sort of glad that the past specific recommendation rules were changed, and I'm sort of not. So just as a refresher, the old rule said you have to give all of your past specific recommendations going back at least a year, because it was an anti-cherry picking prohibition. But in advertisements, that was really honored in the breach. I reviewed very few advertisements, except maybe in some PE or VC context, where every portfolio investment in the past year or every current investment was really given. Most were honored in like the TCW or Franklin no action letters, the top 5, bottom 5, or the objective, non-performance-based, consistently used criteria with no performance information. But those no action letters, in my experience, were really abused. The objective non-performance-based criteria was often used in a single presentation, and sometimes, just got to the place where they wanted to be. It didn't always redact performance information. A lot of presentations gave it. So I'm kind of glad that the prohibition of past specific recommendations, going back, unless you go back a year in time and give everything, I'm kind of glad that went away, because I reviewed very few presentations like that. On the other hand, it's still not going to be the case where you could cherry pick a single great investment, and give the performance, because we still have this subjective fair and balanced and not misleading and don't cherry pick approach. So while a lot of the, the prohibitions went away, the prohibitions on giving a single investment went away, the prohibition on using testimonials went away, these principles still govern in a really subjective way.
Yeah. No, I agree. And I think, we'll talk at the end. I mean, chief compliance officers need to really understand these prohibitions and train their staff so they can recognize them as well. Because I don't think compliance is just lays at the feet of just one person. It's the entire firm.
And question from the audience related to the cherry picking prohibition. So that was something that was previously exist in the old version of the marketing and advertising rules. And a lot of clients used to try and get around it by basically saying, showing their winners and then putting something in the disclaimer saying, this is not representative of our strategy. For a full list of our performance and the securities contained in our portfolio, please reach out to us at XYZ email. We just want to confirm that this change in this rule completely eliminates that ability to disclaim that away. You have to show your winners and losers. You can't get around it with selected disclaimers anymore.
So I'll kick it off, and then, Anna, you could jump in. So the prominence of the information matters. The equal prominence still matters. The clear and prominent disclosure still matters. The consistency across presentations still matters. The intended audience still matters. So I don't think it was ever the case, like you said, where you could cherry pick or really hide things in disclosures or hide things in linked disclosures that were really, really material to the reader's understanding. We can still say a one-on-one communication might not be an advertisement, so you might have more flexibility there, but the fair and balance is still there. So you still can't hide, you still can't give losers in the back of the presentation when the winners are on the first page and 18-point font and the losers are in 5-point font. And I think the SEC basically gave themselves better tools, to go after that in the new marketing rule.
Mm-hmm. Yes, actually, speaking of performance, Scott, maybe you could discuss about the performance requirements set out in the new rule.
Sure. So, again, in some ways it's specific, and in other ways it's really, really subjective. And the final rule release, which unfortunately is not a rule release that you could really sit down in a single time and just read through like a book and absorb everything. It's 430 pages or so, but a lot of it is devoted to performance advertising, which again, shows where the SEC's mindset is at, and that's obviously a clear risk, for investment advisor advertisement. But there were certain rules that kind of were put in specifically. Some are met with more fanfare than others, and certain rules that, again, are simply subjective. So as a general overview, and I think, Anna, you mentioned this before, net is mandated. There's no exception to show gross performance. There's no exception for the audience and sophistication. The ICI no action letter that talked about one-on-one communications, again, assuming it's an advertisement here, and that might matter to the analysis, there's no exceptions built in other than what is or isn't an advertisement that you can show gross only. There's no exception that if you're showing a specific portfolio investment that you could show gross only. It absolutely mandates net. It mandates equal prominence for net and gross. It mandates consistent time periods used. For not private funds, it mandates a 1, 5, 10 year and since inception performance, but it does carve out private funds. And a lot of the old kind of rules, allowing a model fee, but not if it gives a higher return than actual fees, or not if you use the lowest fee charged instead of the highest fee charged, that carried forward. And interestingly, there's no particular calculation methodology that carried forward. So in some ways, the SEC tried to allow investors to compare apples to apples by like the 1, 5, 10 year and since inception dates, but they didn't mandate a methodology. So there's still a lot of disclosure that needs to be added, and a lot of clear and prominent disclosure that needs to be added to make sense to the reader of what they're reading. And again, it will depend upon the audience as to how much the SEC thinks it makes sense. The rules talked about related performance. It didn't go far to say that you could use a single fund or a single account as a representative example, but it did say you could kind of carve back a related portfolios and just use a subsection of those related portfolios. The SEC was still concerned about cherry picking, but it did allow it to use related performance and not give every single performance result of related counts if it's not materially higher than if you gave everything. It does allow you to use extracted performance. And again, in market practice, I saw this over and over in practice anyway. So advisors took a subset of a multi-strategy portfolio and said, we're just going to show the credit because now we want to do a credit fund or a credit strategy. And this fund was multi-strat, so we're just going to take the extracted, credit out of it and show that. I already saw managers doing that. So it's nice that the SEC acknowledged that you can do it. And it's nice that they acknowledge there's some merit to it. They acknowledge there's some merit to hypothetical performance. They acknowledge there's some merit to targets and projections. But they also brought in those subjective criteria to again, not mislead, not cherry pick, and be fair and balanced. And anything that's not actual, other than an extracted performance of a single portfolio, so that includes an extracted performance of multiple portfolios, is hypothetical. And there's additional criteria around hypotheticals. And, I'll add one more point before, I turn it over for discussion, is model portfolios, back-tested portfolios, and targets and projections were all lumped into hypotheticals. And the SEC didn't go so far as to say you couldn't use hypotheticals. They didn't go so far as to say you couldn't use it to retail investors. But they did make clear that the intended audience mattered. They did make clear that the disclosure mattered. They did make clear that not all hypotheticals are equal. So if you have a paper model versus a back-tested performance that was done with the benefit of hindsight, they said, think about your intended audience harder. Think about your disclosure harder in that back test than a paper model. It's still, they still were worried about cherry picking because you could still have, when I say paper model, I mean actual trading on paper. So not actual gains or losses in a bank account, but real-time trading on paper. So you weren't totally with the benefit of hindsight, but you could have had 20 of those running at the same time, and 19 of them did terribly on paper and one did great on paper, and you only show the one that did great. So the SEC said, hey, hypotheticals can still have merit. You can use them. And they didn't go so far as to say you can't use them in a retail context, but they certainly gave some strong warnings to think about intended audience and who can understand the disclosure you give.
Yeah, I was gonna say, I agree with you. And I do actually, I'm seeing more and more hypothetical / model performance being used and advertised to clients, especially to more, for separately managed account, wealth advisor type clients. And I think it's very important for advisors to, if they're going to be using hypothetical, to adopt the policies and procedures that are reasonably designed to ensure that hypothetical performance is relevant to the investment objective of the intended audience. And it's really important for the disclosures to be solid and to ensure that, the audience, the intended audience, like understands how this model or how this hypothetical performance was developed, and all the calculations that go into calculating that performance, including there could be like dividend reinvestments, or what happens within the model when how frequently is the model rebalanced, as opposed to if an actual account is invested in the model, the performance can vary widely, and we've seen that in practice. So again, just ensuring that the hypothetical model is really intended for the audience, that they understand the basics of the model, and to provide reasonable information, disclosing the risks and limitations by using hypothetical performance in making investment decisions. And to your point, there was distinction between retail or non-retail.
Yeah, and they declined to do a strict distinction, but they still, in their commentary in the final rule, distinguished. So, I feel a lot better advising private fund managers or wealth managers with institutional clients or really sophisticated high net worth clients to do things like hypotheticals than I feel as certain advising like a digital advisor with a retail client base now. Because even though the SEC declined to do an absolute prohibition, they still clearly really cared. And even if you put really robust disclosure, in huge font and link it and make them click on a box that says, I have read it and understood it, the SEC seemed to suggest that anything you tell to a retail investor just may be over their head. So it almost, in some ways, doesn't matter if the hypothetical is so sophisticated or so nuanced and the assumptions are so nuanced that no matter how much you tell a retail investor, they just won't understand. So that you could have them click on anything, you could have acknowledge anything, but the SEC will still look past that. So, I really feel a lot better in what you could do for a private fund manager now than what you could do with a digital, robo retail context with this new rule than even I did under the old rule. And it still, again, poses a lot of pressure on that record keeping, on having, evidence that who your intended audience was, and having evidence of what you intended to show and how you described it, and the contemporaneous review by compliance. And when you get into those hypotheticals, an interactive analysis tool, are not hypothetical. So for those robo-advisors, you could still have something that says, well, if I assume this percent inflation and this percent return, here's how I can evidence compounded returns over time. You could still have those kind of tools, but think really twice about especially back-tested performance. But private fund managers, or high net worth accounts, I feel a lot better using models and back tests and even targets and projections, than I did before.
Mm-hmm. Yeah.
Another question from the audience.
Go ahead, Jared.
For hypothetical performance, will it still require to be net of fees, or are they allowed to use gross for when they're using hypothetical performance?
So I can add my thoughts, and Anna, you could agree or disagree. Net is mandated. So if it's an advertisement, net is king. It was king under Clover Capital, And, Clover Capital, we could talk about whether that's dead or not under the new rule, but it's still king. We could carve out exceptions on one-on-one communications that aren't advertisements. And this is one where I think is it an advertisement will make a difference or not. But if it's in an advertisement, in hypotheticals, even on one-on-one communications, generally advertisements, unless, requested or unless private fund investors, net is king.
Mm-hmm. Yeah. And along those lines, and maybe we're moving ahead a little bit in the interest of time. Oftentimes clients will recommend other advisors for investment in their client and for their clients. So I know oftentimes the underlying advisors just assume that those advertisements, those pitch books from the other advisors are 100% accurate. So what is your recommendation on using third-party unaffiliated managers' marketing materials when an advisor is recommending that an investment in that fund to one of their clients? They're still responsible for at least reviewing that material, but maybe not the content unless they actually alter the content or extract some of the content to create their own bespoke marketing materials. Is that kind of how you're viewing the use of another
it is one
materials?
Yeah, I agree with that. One of the plain English rules I use to myself is, who does the reader think is speaking to them? So, to your point, where you extract information from, a presentation from an institutional manager that offers a whatever it may be, a fund, an ETF, a registered product, when you extract it and the reader thinks it's you, recommending it, you talking about it, and it's your content, that's going to be your advertisement. And that's a little bit the tricky part of the direct or indirect, part of the definition. And the or indirect replaced a means of dissemination, and the SEC said they decided those words meant the same thing. But in the legal world, the words have meaning, and different words are usually construed as different because why else did you make them different? So I think there will be pressure over time to talk about that indirect communication. But if you're just doing a wrapper and you're saying, this is other managers' information, I think it's reliable, but I don't deem it, I think it's reliable, but I don't guarantee that it's true, complete, and correct, but it's theirs. I don't think that's still your advertisement. But to your point, Anna, if you're extracting information and the reader thinks it's you talking to them, that's going to be your advertisement. And then, again, the pressure of identifying fact with a source and having something in a file that supports that fact and identifying opinion as opinion will become ever more important. It was always the advice that I gave: source fact, identify opinion, but it's becoming even more important under this new rule.
Mm-hmm. Yeah. I think just to maybe go back to the testimonial and endorsement a little bit. Oftentimes our clients that are evaluating the rule ask us, okay, well, what does that mean? What is, direct or indirect compensation? And what type of disclosures will I need to make? And especially as it relates to testimonials or endorsements, clearly, paid disclosure, direct compensation should be disclosed at the time of that endorsement or testimonial is made. If it's made orally, an accompanying written disclosure should be provided to the particular client, prospective client, or investor. When it comes to the indirect, so for example, somebody is referring clients over to an advisor, and so therefore it's an existing client and they're getting a fee break, for example. So under this new rule, that relationship will need to be disclosed and the compensation needs to be disclosed. And even if it's over a period of time, those facts need to be disclosed because the prospective investor or client needs to understand the motivations of the person providing the testimonial or endorsement, and their incentive, if you will, for providing such endorsement. And the prospective client or investor needs to, consider that and weigh that as prior to making an investment with that particular advisor. And, so oftentimes it could be just, slapping a label like, paid for advertisement, but the more granular disclosures, I think, really need to be there. They need to be there clearly and prominently so that the other client or investor understands that. What do you think on those terms? Do you agree with that interpretation?
Yeah, totally agree. And, some of that clear and prominent disclosure has to be right up front. The fact that they get paid, the fact that they are an existing investor. Some can be given later or linked or hyperlinked depending upon the form, like the exact compensation or the exact fee break. But there's definitely a push in this new marketing rule to be really specific on the exact compensation, even to monetize non-cash compensation if it's at all possible. And that's why that second prong, is leading a lot of the fund managers I speak to that have those instances where they have investors in particular helping them market, for lack of a better term, or introducing investors that previously didn't fall under the cash solicitation rule, at least specifically or technically. It's causing them a lot of hesitation to quickly move to the new marketing rule. And, right now, as a takeaway, what chief compliance officers or GCs should be doing, especially if you're a fund manager where the new marketing rule now applies to fund investors, is list out your relationships that could be testimonials or endorsements, including the solicitation component. And certain ones will be obvious, your placement agent agreements. If you're a private fund and you have a broker that's marketing your fund interest, clearly, that's a solicitor. If you have a cash solicitation arrangement, if you're a wealth advisor or robo-advisor now, clearly that's a solicitor. But you can have bloggers, especially not so much private fund managers, but more, again, digital advisors can heavily use bloggers. And the direct, indirect compensation, cash, non-cash compensation, that doesn't say, success fee, right, is how you determine who a solicitor is. So those bloggers can be endorsers. They could be, if they're current clients, testimonials, and can fall under the rule. Associated persons of the advisor. So under the broker safe harbor, private fund managers may not deem their investor relations personnel to be brokers, but they may very well be promoters under this rule, and you may have to add to your employee certifications for the bad actor checks. You're already doing that for ADV bad actor. You were already doing that for 506 bad actor. Now they could be promoters under this prong 2 of this rule, and you have to add to that annual questionnaire the increased expanded bad actor disclosure under this rule. So you need to think about that. Your cap intro arrangements. Oftentimes, we don't disclose that as formal, like soft dollars, but there are a lot of them out there. And those cap intro arrangements can now be solicitations that apply to this new rule. And there are exceptions to the criteria, and Anna, you had mentioned it before, of the disclosure and the advisor oversight and compliance, the written agreement, and the disqualification provisions. There are exceptions in certain cases, de minimis, refer a friend program that are under $1,000. Your associated persons that are affiliated with the advisor, there are certain exceptions. You only have to comply with some of those categories, not all. Non-compensated, you only have to comply with some things, not all. But you really need to sit down and think about who now falls under this second prong, and reassessing the agreements that you already thought of as placement agent agreements or solicitation agreements, and reassessing your arrangements that you didn't previously think of as testimonials or endorsements that now are.
Mm-hmm. Yeah, there's so much to the rule. I know we're getting close to the end here. One last thing I wanted to mention before we go into our recommendations is the third-party rankings. Oftentimes, for firms apply for and win various awards from, Barron's, from Forbes, from, local cities and towns. And I know Jared and I and a lot of my colleagues have seen quite a few third-party rankings. But anyway, the rule does address the third-party ratings, and it specifically, again, calls for disclosure regarding what was the criteria for applying for this third-party, rating, did you have to pay? Was it compensated? Was it not compensated? Was it, what were the assumptions that leading up to the determination of, whether or not you're winning? So disclosure as it relates to third-party ratings is required, and especially if there are compensation arrangements, they need to be also disclosed, and any conflicts of interest, because the reader has to understand the motives behind the particular, third-party ratings for that.
Yeah,
so,
and the subjective criteria of those general principles also now makes you not only disclose all that, but makes you sit down and think about, were the criteria of this rating, predetermined? Like, was it designed to produce a certain outcome? And if so, you can't use it, because that would give a misleading inference. So even if you disclose the criteria, you still have to think about, was this a bad criteria, or was it a good criteria, and was it okay, and did it lead to a certain conclusion, that was already predetermined? So, and again, that puts pressure on your contemporaneous books and records, that you thought about it, you considered it, and you think it's okay.
Mm-hmm. Yeah. So I don't know if we want to wrap up with, what we're recommending to clients and chief compliance officers. We always stress that, and again, we're biased, but, the chief compliance officer and compliance should be like woven into all aspects of the firm's business. I mean, without having that chief compliance officer be participating in meetings, being CC'd on information, being part of the different governance infrastructure that advisors have or should have. That's how the chief compliance officer can best identify potential risks, identify conflicts of interest, and try to mitigate and force the disclosure of some of these events. Because oftentimes when our clients are under SEC exam, or we are requested to assist clients with SEC exams, it's not that people intentionally violate compliance policies and procedures. What we find is they just, if you're outside of the compliance team, you're not thinking compliance all the time. So that's why it's so important for the compliance officer to be, involved and understand aspects of the firm's business, and especially now as it comes to the marketing rule, have that compliance officer understand the nuances, how it applies to their firm, and then provide training and educate the staff on the changes with the new marketing rule, and the additional flexibility it provides, and then the restrictions and disclosures that go along with it. Because I have a feeling the SEC will probably do a sweep exam in a couple of years, and we'll see some some division of examination risk alerts coming out from this. And again, I think the devil's in the details. And we'll see how it rolls when everybody starts adopting it.
And I'm asked for my final thoughts here. I'm asked constantly by CCOs, where do I start? Or how do I start? What should I be thinking about now? So, here's basically the framework that I give people to start. Is one, inventory your current marketing efforts, and that includes solicitation now, not just your advertising. And that includes things, like I said before, that you might not have thought of as solicitation, but now are under the new marketing rule: your affiliated persons, your cap intro, your existing investors. When you have that inventory of what you currently do, inventory with your marketing team what you want to do. So what kind of marketing is their ideal? Do they want to do things on social media that they weren't doing before because you said they couldn't? Do they not? Do they want to do things on LinkedIn? Do your employees want to do things on LinkedIn or Facebook? Like, highlight, giving that thumbs up or thumbs down little click, that they maybe can, that you previously told them they couldn't. Under the new rule, they can. So inventory what you currently do, and inventory what you want to do, or what your marketing team wants to do. And that will help you to determine really, how quickly you want to go over to the new marketing rule, whether you want to wait till November 2022 or you want to do it right away. When you have it inventoried, then you can reassess your policies and procedures, and you're probably going to need desktop procedures for certain marketing activities. So if you move over to the new rule because you want increased social media presence, because you want to use testimonials and endorsements, you'll give a policy that gives the overview of the rule and some education and what no action letters, were incorporated into the new rule and what we're gotten rid of. But you'll probably need some specific operating procedures for those specific new marketing activities, especially social media and testimonial and endorsement driven, over exactly what is permitted and what's not permitted in that context. Then you can reassess your marketing materials themselves and your disclosure to make sure they're clear and prominent, to make sure they're suitable for the intended audience, to see what kind of hypothetical are there versus other kind of performance. Then you can reassess your solicitation agreements because you've inventoried your current materials, you've inventoried where you want to go, you've assessed your policies and procedures, including specific policies to specific plans. You've reassessed your marketing materials and disclosure. Now you're going to reassess your solicitation agreements under the new rule. And then last, you're going to reassess, and hopefully these won't really change all that much, your private placement memoranda and other more regulatory or governing documents that might now be considered advertisements to see if they will become advertisements and you need to change anything in those. And that's the framework I give people, and that framework will help you decide when to move to the new rule and how to move to the new rule. And Jared, I think we should read the CLE code.
Yes. Just 1 second. There's a couple of questions from the audience while I pull that up. The first is, are data rooms considered advertisements?
I think it depends what is in the data room. I know we're going a little bit over what type of material is in the data room. So I think it's pretty specific to the types of materials. But however, I would capture it, and if I was the chief compliance officer, review what is being posted in the data room.
Yeah, it's the unsatisfying answer of maybe, but that's the answer is maybe. But you couldn't whole shot rule it out, that they always are or they never are.
Right.
Understood. And what about, can people post comments on the advertiser's website, or would that be prohibited under the rule?
It's not per se prohibited. It could be a testimonial or endorsement, which is not per se prohibited anymore, but you do need to assess how you permit it, whether you highlight some comments over others, how you organize it, how you present it on the website, who you permit to do it. So that's all that, yes, you can permit it, but you still can't mislead. You still need to be fair and balanced, and you still can't cherry pick.
And I think as it relates to the website also, Scott, you can't manipulate that data. So if you had a lot of people giving you thumbs up all the time and some people giving you thumbs down, you can't hide the thumbs down and just show the thumbs up, So it's, I think when it comes to social media, the lack of manipulation, so it has to be raw data. So you're going to take all comments. You can't delete the bad comments or the bad, the unlikes or whatever it is.
Yeah, I think you can delete the obscene, so the inappropriate. I will say the bad words, the attacking or threatening, but you can't delete the negative. Right. At least insofar as it goes to the advisor's advisory services.
Okay.
Understood. I'll read the CLE credit, and then we'll do one more question to wrap up, and I'll read it again. CLE, everyone that needs it, the code is 59879. And I'll read that again in a second, but we'll do one more question. Sure. So this one is just to clarify, presenting backtests of, let's say, an algorithmic model is acceptable under the new standard as long as both net and gross are presented, as well as the full details of the assumptions.
So that's a hypothetical. Hypotheticals are, again, permitted, not per se prohibited. Whoever asked the question is correct. You definitely need to disclose the methodology. The net is a good thing since net is king. I will say the context, in addition to the content and the channel of distribution, matters. So exactly what the methodology to use for that hypothetical and the intended audience will matter as to whether it's deemed misleading or not. And if that's a private fund manager asking that question, again, I'd feel a lot more comfortable than if it's like a digital advisor or robo-advisor with a retail platform asking that question. And the sophistication of the back test and the sophistication of the assumptions will all matter. So not prohibited, but subjective. And that'll be the fun of the new marketing rule, is not prohibited, but totally subjective.
Actually, Scott, one more question just before I read the CLE. In your opinion, is this a big sea change? Is this a big regulatory change? There's a lot of things that were kept from the old previous rules. How do you feel about this just generally, a big change of the tides?
I think for some managers, it will be a big sea change. For those managers that want to be innovative, heavily use social media, start to use those spokespeople, testimonials, endorsements, it's a big sea change. For some managers, particularly large private fund managers, they're not going to change how they market. They're not going to be aggressive in those testimonials. They're going to stay down the fairway, and it's not going to be a huge change at all. It might be a huge change on the cash solicitation part of it and the solicitors, but as far as how they advertise what they show, may not change at all. So in some ways it'll be a huge change, some ways it won't. Anna, what's your feelings on that?
Yeah, I agree. And I think, as I said on the outset, it really depends on the type of advisor and the business they conduct. Some of our private fund advisors are just that, very private, and they do want to stay under the radar. Others, again, mostly our wealth advisor clients are looking forward to, starting to analyze when they will embrace the new rule, especially take advantage of the testimonial and endorsement piece of it.
All right, and just once again, the CLE code is 598879. I just wanted to say thank you once again to both of our panelists for taking the time today. It is incredibly appreciative. I hope everyone found this informative, and hopefully we'll be able to do a follow-up as the the compliance date comes closer next year. But once again, thank you, Scott. Thank you, Anna. It has been a pleasure.
Thank you. Thank you, everybody, for listening. And for those seeking CLE credit, you will get a communication with a link that you can click on and fill out with your name and that access code to then get the CLE credit. And thank you, everybody, for listening.
Thank you,
Anna and Jared.
Thank you, Scott. Okay.
Thank
Bye.
you.